following program is classified G. It's suitable for all ages.
Tonight, we discuss the highly contentious 22nd Amendment to the Constitution. The recently gazetted 22nd Amendment is inclusive of provisions that were present in the 19th Amendment of the Constitution. Concerns have risen as to whether this is the most appropriate way forward for Sri Lanka, especially with regards to its executive authority. What are the proposed legislative changes in the 22nd Amendment? How will it change the course of Sri Lanka in the coming years? Welcome to Law, Land and Liberty, where we are keeping with the promise of bringing in a contemporary legal topic and breaking it down for our viewers. Now, the discussion that is happening within the public area as of now, within even the legal fields and even outside the legal fields, is the 22nd Amendment to the Constitution. The first question that everyone asks is, why is it not called the 21st Amendment to the Constitution, given that there have been only 20 amendments? And a lot of clarifications required from that point onwards moving forward. So a novel initiative and a novel concept to all Sri Lankans, something that will change the course of our country in the years to come, and we really need to get a proper take. And generally within this program, when there is something of historic concern, something that will change the trajectory in our country, we generally go to President's Counsel, Silva, to get a breakdown. Thank you so much, sir, for joining us again. As everyone knows, I'm pretty sure introduction is not required to the layman watching President's Counsel, and Silva is the former president of the Bar Association and has been present very much actively within the public area these days when it comes to the reformation of the law and the legal field in general. Sir, once again, thank you for joining us. A very large portion, a large discussion area that we have for today. The few things I want to explore, and we can start off from getting a general breakdown of how that. Firstly, if you can answer the question, I think the Minister of Justice also made this clarification in a media briefing, but if you could rehash that on why it's called the 22nd Amendment and not the 21st, and then we can continue.
It should be clarified, because now we know very well that during Gotabaya Rajapaksa's regime, 20th Amendment was passed in the Parliament. So that is the main crux of the matter. It was passed in the Parliament. Thereafter, it was there. And then people were not happy with the 20th Amendment, and then they are asking the 19th Amendment, and thereafter they say that the president's, the particular post as the presidency should be abolished like that. Yeah. So then one day the Minister of Justice, Mr. Rajapaksa, President Counsel, brought a members' bill.
Private member bill.
So that is called, a member will bring that in Parliament. That is there. It is accepted, but it will take some time.
The process is slower.
Than the other cabinet approval thing. So he brought amendment to the Constitution 20th. Then thereafter 21st. Yeah. It was there for a while. And then in the meantime, Sajaba, that is Samaga Jana Balavege also, they wanted to have a big issue, and then they wanted to amend various parts, including the presidency. Yeah. So that is how they prepared that document. Through their secretary, it was submitted, and it was there in the Parliament. Then automatically, after 7 days, it was before the Supreme Court. So when the Supreme Court matter was argued, the Vijayadasa Rajapaksa President Counsel withdrew his amendment, that is 21st. Then the 21st was there to argue before the Supreme Court. So Supreme Court determination was sent to the Parliament, and it was clearly stated most of the clauses there in the 21st Amendment, according to Supreme Court, it was not in accordance with the present Constitution. So we have to understand, we can't change the whole thing haphazardly or by going to Parliament, because 1978 Constitution is still there. So within that frame, we have to do something without going beyond that. So that is why the Supreme Court has clearly stated, if you want to have those amendments go through, you have to go to Parliament, get the 2/3, and then the referendum also. So that is impossible task. So that is why they have abandoned. In the meantime, as assured by the President Gotabaya Rajapaksa, he asked President, our new Minister, Minister of Justice, to prepare a bill for the 22nd Amendment. Right. It was already there in the Supreme Court. That's why they called it as 22nd. Right. So when it goes to Parliament, of course, they might say this is 21st because there is no 21st at the moment, because they are not proceeding with the Sajaba is not proceeding with the 21st Amendment, which they have submitted to Supreme Court. Anyhow, now the Vijayadasa Rajapaksa President Counsel, within his frame as the Minister of Justice, he prepared the 22nd Amendment, and then thereafter it was submitted to the President. But unfortunately, President has some clause. He has given permission only with regard to the clauses where he says, after my period is over, it should come into operation.
Right.
So that is why that particular clause is there. But I think it was not the issue earlier, because most of the people, they say, if you are going to stay, you have to curtail your powers, and it should be given to the Parliament.
From the time the act is, the amendment is brought to there is this tenure itself.
That is, that 22nd Amendment is passed, and then immediately it should come into operation. Yeah. You can't have clauses, you can have, but no purpose of having that, because it is not the people's wish. Yeah. So that is why it was there for. In the meantime, there were a lot of things happening, and then thereafter, Ranil Wickremesinghe came as the president of this country, and he assured that 22nd Amendment will be there immediately. Yeah. So that's why it was given to the minister, and minister prepared. He has removed those clauses, and then it was submitted to cabinet. Once the cabinet approves that, then it goes to the gazette notification. Yeah. It was gazetted. Yeah. Then now, after 7 days, it was in the order paper in the Parliament. Yeah. So after that, within 7 days, any person, any citizen can go to Supreme Court, not the particular parties or the other institution, but individual also can go to Supreme Court and state whether there are any inconsistencies within that 22nd Amendment. Okay. The Supreme Court will decide only with regard to the consistency of the clauses. So if they are of the view that they are not going to go against the 1978 Constitution, then they will say we have no objection for that, or our determination is this, and you can proceed with that. If there are, according to the Constitution, amendments we have, if the Supreme Court is of the view there are clauses where you have to get permission from the people by way of a referendum, then the government has to decide whether you should go through it, or halfway through they will amend, or they will drop those clauses. So that is how it goes, and then most probably within 2-3 weeks time we can get the determination, and after that we can see the Parliament will debate it, and in the debate itself that these clauses can be changed. And if they wish, they can give an assurance to the Supreme Court that during the committee stage, we are going to amend. It is happening. Yeah. So, in most of the earlier amendments also, that is with regard to other clauses, they have changed it while the committee say debate is going on. So it can be done in that way, not going against. we have the experience where Supreme Court determination was ignored in some cases, but here of course they will give an assurance to the Supreme Court that they will act according to the Supreme Court determination. And we have to remember that this is only an amendment. This is not the new constitution.
Yeah.
So we cannot abolish the presidency at this amendment, even if we want to have it. So people must understand that. Most of the people who are making a lot of big ha-ho, they say president should go and then abolish the presidency and then go proceed further. No, you can't do that. We have to discuss these things. In the first instance, it cannot be done by way of amendment. And then if we are going to do that, there are two new constitution pending.
Yeah.
Right? One is by earlier government, where they have prepared a constitution, and then subsequently Gotabaya Rajapaksa also appointed President Counsel Romishti Silva, and they have prepared it. Already it was submitted to the president, earlier president. It was pending now. So people can go through it and then see what are the new things and what if our wishes will be there or not, and then thereafter we can have a new constitution. We have to have a new constitution, but it cannot be done in 2-3 months. It should be go to the people and see what their wishes would be, and their suggestions should be considered, especially the younger generation. They are making a lot of suggestions, so we have to consider those things, and then only Parliament can pass the constitution.
Mrs. Silva, a very good opening segment there that we got a lot of clarifications, but at the same time I have few things to clarify. Now, I think you addressed something very important pertaining to the people's claim of removing the executive presidency, a very sudden and very rash sort of claim. Just to re-clarify that, with an amendment, it's still possible, but there will be the stage of there will be the 2/3 majority requirement and referendum requirement if the Supreme Court says so. Or at this junction, we cannot abolish the executive presidency. It has to come through a new constitution. How does that?
No, it has to come through a new constitution. It's a better way.
Better way. All right.
So if we want to have it, that means that we are going against the 78 constitution.
Exactly.
The 78 constitution was prepared on the basis of the presidency.
Yeah.
So he is the person who is commanding the Sri Lankan government.
The executive president.
Executive president.
Yeah.
So on that basis only we came to this point. So suddenly we can't change it because there is no mandate for that.
Yeah.
So to get that, we have to have a new constitution. A better way of doing it, have a new constitution. It was started in Chandrika Kumarthinga's time. They have prepared a constitution and it was gone to the parliament.
Yeah.
They burnt it openly. So unfortunately that was happened. Thereafter only Yahapalana government tried to do that. They are also, they put forward, but because of one word, that is Orimuttu Nadu. So that is the word people were very concerned. Then on that basis, the Yahapalana government abandoned it. So then that constitution is to consider, and the new constitution also already prepared, and it can be considered whether it is now abolishing is a different thing and curtailing powers is different. Yeah. My personal view in a country like this should have the presidency. Yeah. It is very important as far as the security is concerned, as far as the provincial government is concerned. There are provincial government. So then because of that, presidency is very important. But whether we are going to give more and more powers to president or curtail the powers, and then powers should be given to the parliament and go ahead. Yeah. With those things can be discussed, and how are we going to draft it also can be discussed and prepared.
Right. A very important opening segment and a number of questions that I have for you, Mrs. Silva. But we'll take a very short break. We are in conversation with the President's Counsel, U.R. De Silva, and we're talking about the 22nd Amendment to the Constitution of Sri Lanka. Stay with us. Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel, De Silva, and we are talking about the 22nd Amendment to the Constitution. Now, for the viewers who are just tuning in, we have passed the segment on talking about the context of how the 22nd Amendment came into play, the differences between the 21st and 22nd Amendment, what that confusion was, and the procedure if there is a challenge against the 22nd Amendment. President's Counsel, I think we need to give our viewers a bit of a take on the integral aspects. And the first thing, as like I go through the amendment also multiple times, is the Constitutional Council and the clarification that is required there. Because if I'm not mistaken, the 17th Amendment is where this was initially introduced. And
firstly, it was there, and thereafter 19th Amendment, it was again considered, and then changes, and now they have brought back again, because 20th Amendment, it was abolished. So then now they say it is very essential to have 19th Amendment.
The Constitutional Council.
Constitutional Council. That is the main area they have concern. So that Constitutional Council, we have 10 people. So within that period, people, they have to decide.
Mr. if you can provide that breakdown, where the initial issues were with the Constitutional Council, as in when the 20th Amendment came into play, and now what we are seeing in the 22nd Amendment. Now, obviously, we need to understand that this could change in the days to come, because there's the possibility of people to go into the Supreme Court. The Parliament can also discuss this. We have seen that happen, and you explained that really well. But as we see it now, what are the key features, the salient features when it comes to the Constitutional Council?
Yes, now Constitutional Council, we say 10 people should be there, and Speaker is the chairman, so most probably he will not take part in the election, of course. If there is a problem, then finally he will take the decision. Anyhow, 10 people, then how are they will be appointed? So there's Prime Minister, Speaker and Opposition Leader. Those are main areas where it has been there earlier also. So thereafter, a member from the Parliament appointed by the President. So President has the power, so he doesn't have to ask anybody. He can appoint one person from the Parliament. So then there are 5 people again to be appointed. Then out of those 5 people, 2 are from the Parliament. That is also one person, one parliamentarian from the government side, and one parliamentarian from the opposition side. So those people will be selected by those are in charge of the particular parties, and thereafter they will be there to be nominated by the President. So then the other 3, of course, are outsiders, where it is clearly stated the persons of eminence and integrity should be appointed to these 3 posts. So that is, of course, it's a bit difficult thing. How are they going to appoint those people? Earlier, we saw most of the people appointed were from the non-governmental organization, so NGOs. So we are not satisfied with those people, and what they have done was they have not stated what we expected. So they did what they want, but we saw the repercussions of those decisions. Anyhow, how are we going to do is the issue. As I said earlier, I think according to Samaga Jana Balawega, they have considered 3 people in this way. That is, 1 person from the OPA, professional organization. They have been given 1 slot.
This is the Organization of Professional Association.
That's right. One slot is there. And then Chamber of Commerce have been given 1 person. And then the professors. University academic.
The UGC. That is
so the UGC have the power to appoint. So my personal view is that is a good move where they can come and do a good job for the betterment of this country. They are not parliamentarians, and it is clearly stated those 3 people should not be a member of any political party. So they are independent. right? So then it will be discussed in Parliament as well. I don't know whether in the Supreme Court also the AG will give an undertaking to amend that in that way, or else they can go to the committee stage and do the needful, because by appointing these people it will be a problem. And the final slot is also a problematic thing, where it is clearly stated without the government party and the opposition party, there are other small groups, they should be considered when the Constitutional Council is being appointed. Right. So that is why they have been given one slot to be appointed. So how are we going to do that? So whether the Parliament will take a lot of time to appoint that particular person. So most of the small parties, they will claim that we should have that slot to us, and then there will be problem. It was there when, as you said, during Mahinda Rajapaksa's time, it was there, this particular problem was arose. And then Mahinda Rajapaksa clearly stated that I had a big problem with regard to this whole thing, because they have not appointed the person for a long time. They prolong it. So because of that, no decision can be taken
by the Constitutional Council.
By the Constitutional Council. That is why he ignored that and proceed with the presidential powers. Right. So we must avoid that. With that experience, how are we going to solve that problem? It is very easy to criticize and give suggestions, but when the practical side is being considered, how are we going to do this, and how are we going to get the maximum out of is the important thing. Otherwise, this Constitutional Council is no purpose of having that. So if we are going to have it for the betterment of Sri Lankan society, we should have proper people. And it is important to state whether we want to do some service or whether we want to have our political agendas fulfilled or not. That is why we have to consider we may have a lot of committees, but the fact remains that whether we want to do some service to the country. Now with this past experience, but we had past few months, we have to take a firm decision that if we are not going to work hard and do our best for the country, then it will be a chaos situation, and it will be argued every time, and people will come to street. Now it has been done, because now they take it very easily. So they will take the law into their hands, and they will come to the streets, and the police have to curtail or the safeguard our society. So they have to do a lot of things, and finally our purpose is lost. So after removing the earlier president, what have we got from that point? So only thing is the president was appointed. So we hope and pray that he will do some service. Now here also they are not satisfied with. How are we going to satisfy them? Now by passing this constitution also, whether we are in a position to do that. So sometimes they might come and say this Constitution Council is not properly being appointed. Right? We are not satisfied. Can they do that? If they appoint a person on behalf of them to the Parliament, they have to listen to them. Now they are one good thing is, they say if we are not satisfied the particular member, we must have a chance to recall him. Recalling procedure, it should be there in the Constitution. Whether in this particular amendment we can have it or not is a problem. That is why I think Mr. Vijayadasa Rajapaksa President Council has not included that. It's a new thing. So he has given an assurance without going for a referendum, we will try our best to pass this constitution, because we can't go to a referendum. It's like election. So we can't spend a lot of money for that. So avoiding that, we will stick to the things that are there at the moment. We should be satisfied with that without criticizing it. We must get the maximum out of this Constitution Council. So if it is properly appointed by the people who are responsible, then it can work very hard and do most of the appointments according to the constitution amendments that are being presented.
Right. Mr. Silva, before I move to the next question I have was going to be on the role of the Constitutional Council. But one thing I want to clarify, I think what we were talking about was 41A, which is the amendment that is going to talk about who should be within the Constitutional Council. And the issue that you pointed out, I think very important, was on when the Parliament cannot agree on that one representative. There is a provision if there's an issue for the Vice Chancellors, as in within the UGC, to mention that is under G, that mentions the chairman of the commission shall nominate a professor by the majority vote. So even within Parliament, a majority vote would have to take place in that instance to appoint that one individual. Is that how we go forward?
Yes. Yeah. Now, according to this amendment, it is going to happen in that way. The majority should give permission. Otherwise, if we are going to allow them to appoint the way that they wish, it will take long time, and they will have a lot of arguments within themselves. Exactly. So better to have that majority decision, because in all the appointments it is clearly stated with the majority decision of the Parliament. So it is very clearly we can see what they expect. That is, without prolonging it, you can go ahead with the majority of the Parliament.
Right. Now, Mr. Silva, if we can go a bit deeper into the function of the Constitutional Council. Now, we hear a lot of conversation about it, and I'm not too sure if the people protesting against the Constitutional Council are also aware of what it actually does. Yeah. So if we can give a bit of a take on what exactly the role will be and how that will affect the executive's power and the legislative's power, how all of these three will function.
Yeah, now earlier, when the appointments were made to the commissions and boards, also it was done by the president himself, and he has the authority to do so. Yeah. So people were criticizing that they put all their people, and without considering their eligibility, they have appointed them. That is why the whole system was collapsed. Yeah. Likewise. So with that experience, if we are going to allow the Constitution Council to do this chairman and members of the commission, and especially the central bank governor also being appointed to the particular post, it should be done by the Constitutional Council. So earlier it was not there. Now they have given that opportunity to the Constitutional Council, even the monetary board. So those are very crucial and important areas where our country is concerned, because we had the experience. So they have appointed various people unnecessarily. They took very haphazard decisions. Because of that, our country suffered. So that is why they have clearly stated those appointments should be done through the Constitutional Council. Even the President wants to have it, he can nominate people. Out of the nomination, the Constitutional Council can appoint people.
Right. Ms. Silva, something I want to clarify at that point, because you mentioned some of the people that will be getting the appointments, the central bank governor, and those are very important roles in our country. If you can talk a bit about the judiciary now, a confusion that I had, you clarified that for me about how the Chief Justice is appointed, and then the other roles of the more senior courts in the country, how the main appointments are being made. Can you tell us how that's going to happen, how the Chief Justice is
appointed? In our country now, we have the experience that most senior person will be appointed as Chief Justice. There may be exceptions where the President has to give some sort of clarification for that, of course. Now, after appointing the Chief Justice, other appointments are very important, where you can appoint on your own. If the President has the power, he can make those appointments on his own. So to avoid that, it is clearly stated, if the Constitution Council also does not have the full power, it is clearly stated you have to consider or consult the Chief Justice while appointing President Court of Appeal and the Supreme Court judges and the Court of Appeal judges. So those are the main areas where they have to take the responsibility. Only they themselves cannot take, then they have to consult the Chief Justice and do the appointment. For the other things, of course, they don't have to do that. There are other commissions, especially 2 important commissions have been included in the new amendment, that is called the Audit Service Commission. That's a very important thing where a lot of people asking that why it was avoided and it was not there in the 20th Amendment. So now it has been brought again, Audit Service Commission and Procurement Commission. Right. So my personal view also, all those commissions will be there, but whether correct people will do the correct job. Even if you are being appointed in a correct way, if you are not in a way to take decision, if you are going to see all things should be done according to the rules and regulations, no, there are exceptions. Yes. You have to think of the country and take decisions according to the country's benefit. Yeah. There are exceptions for that. In our law, every law has an exception. So if you are not ready to take that exception and do the betterment of country, so then you have failed. So that is what happened earlier. Yeah. So that's why we say we may have a lot of people being appointed to those commissions, very well, very good. But merely because the commissions are there, that does not mean we can get the benefit. If you are going to get the maximum benefit, people should work together and do their maximum and think out of box. Otherwise, if you stick to the rules and regulations which are there, we say them. Most of the people, they say that we have to stick to the rules and regulations, otherwise we will be asked to go to FCID like that. So you don't have to worry about the correct decisions, the lawful decision. But if you take time and if you prolong it, it is not good for the country.
Yeah. I think that was very well put, Mr. Silva. We'll take a very short break and we'll talk a bit more about the Audit Service Commission, the Public Service Commission and the Procurement Commission that we were just talking about. You're watching Law, Land and Liberty. Stay with us as we go deeper into the 22nd Amendment. Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel, Silva. As our viewers know, he was a former president of the Bar Association and has been contributing very much to the reformation process of the law within our country. We are talking about the 22nd Amendment to the Constitution. Number of questions that have been arisen within the public area we have been able to answer. The key aspects now that we have been discussing, Mr. Silva, is pertaining to the commissions that are going to be appointed now. We were talking about the Audit Commission, the Procurement Commission, and these additions that are very much required.
Those are new
things that are being introduced. If you can give us a breakdown now, as I was going over, even within the Audit Service Commission, there are multiple appointments that need to be made, and then there is an entire role to be played. I think something you were really pointing out and something we have also been telling is the person who holds that position should be able to do that role. How do you describe the role of these specific commissions that are being put in play? What are their powers? Where are the issues that arise when it comes to the executive and these commissions?
Oh yeah. Now, when they have been asked to do some service, they have to do the appointments or any services very quickly. Yeah. We have the experience when it has been put to the commission, it will take a lot of time. Yeah. So unnecessarily they are prolonging it. So there is no purpose of having a commission like that. And then we are considering about the corruption system also. So if we are going to have procurement commission, if the procurement commission itself is corrupted, then there is no purpose of having. So that is why I said whether the correct people are being appointed, and even the correct people are appointed, whether they want to do some service genuinely. So if it is so, then they can't have it in their own way. They have to they have the responsibility to answer to the parliament.
Right.
So that is very important. Answerable to the parliament is very important, except the election commission.
Right.
So all the other commissions, which already there were commissions, and we say that there are 2 additionals, of course, then all those commissions except the election commission are answerable to the parliament.
Well, if you can give a small explanation, I think the layman, we tend to overlook these things. When you say answerable to the parliament, that is, will they have to come for a sort of hearing and that's it, or can action be taken against these commissions if they are not performing?
Yes, you are very important question you have asked from me, because now it is very clearly stated that they are answerable means that any time a parliamentarian can question that in open parliament, and then they will be summoned to the parliament, because they should report. Every 3 months they have to send a report to the parliament to state that what they have done up to that point. Then the parliament members can go through it. That's a very good move, where they can go through it and see whether they have done in a proper way, or is there any lacuna, or is there any problem with regard to the things that they have done. Yeah. So in that way, they are also responsible, and they are since they are answerable to the parliament, they are not going to take haphazard action or the decision. So in that way, it is very important. We will have that, and the other important thing is Constitution itself, 156A, it is clearly stated that they are going to appoint a commission to investigate bribery and corruption. That is also very, very important. At this stage, we have a bribery commission, but it is, I don't know whether they are doing a job in a proper way, or they don't have enough facilities to do so. Those things should be considered. And then because of this particular amendment, it is the responsibility of that particular commission to go through corruption and bribery, and then give a report and ask. They have the power to institute charges also with the consent of the Attorney General. They can do so, and that is very important, because IMF also have considered our part, and they have gone through every aspect, and they have clearly stated because of this bribery and corruption, your country is going down. And if you are not going to avoid that, or if you are going to curtail these things, you are not in a position to take our benefits, or we are not going to give any help for you all unless you are genuinely come forward and state that you are going to consider that, and then do some important adjustments to these bribery and corruption. Okay. So that is why they have put forward that particular amendment. I think it is important to have it and proceed further with the consent of the Constitutional Council.
Mr. Silva, I think anyone who's watching would understand that the amendment gives a lot of priority to the financial aspect, as in that is the key area, as in anyone can understand that's a big issue that our country has been having. Now, we are talking about how it will be answerable to the parliament, how these commissions will be answerable to the parliament. Now, when something is included in the constitution, even the general public gets a say in maybe trying or maybe having some form of action in courts. What is that possible? Is there something that I want to ask you, whether the general public can, if they believe that certain commissions aren't functioning the way they, because the general public will be the ones going and doing the complaining, citing in issues of fraud, in issues of bribery. What are the provisions Is it there, if you can answer that, is it there within this? How important is it that it's included within the constitution, that is the most supreme law in the country? And what are the avenues that are presented to the general public to go and challenge certain things done by these commissions?
Challenging is, of course, is very important. And as I mentioned to you, in this particular amendment also, any citizen can go to Supreme Court and challenge it. Yeah. Now, earlier it was within 7 days. Now, after passing this amendment only, we can get 14 days. Yeah. It is clearly stated in the amendment, you will be given 14 days time to go before the Supreme Court. It's an important thing. It should be there, because otherwise 7 days, of course, it too short. Yeah. So that is one way of doing that. And for the presidency also, if they are not satisfied with the powers that had been done, or the president is going to do, then they can go to Supreme Court or Court of Appeal, naming the Attorney General as the respondent, and then get their relief done. Yeah. And thereafter, the other important thing which you have asked, whether the people can do something with regard to the commission which are there in the constitution at the moment. So they can send their grievances or the petitions to the commissions and see whether they are going to do it. Yeah. That is why we say their representative is the person who is there in the parliament. Yeah, yeah. Whether that person is working or is a lazy person, is a corrupted person, is a different matter. Yeah. It is our responsibility to appoint necessary or correct people. Yeah. For that parliament. So if we appoint a person, and then since it is not there here, we have to have a separate clause for recalling. That can be considered later when we are going to pass a new constitution. But at the moment, if a representative from us is there, so that person can ask from the commission whether you all have done this correct thing or not. That is there. So that is why we say parliamentarians has also a responsibility, merely because we say they are answerable to parliament. If they are not going to take up those things, the things that are not in according to the law, if they are not going to take it up in the parliament, if they are going to harass or criticize the other parliament members, yeah, and get their maximum benefit, it is not happening. Yeah. So if they are really wanted to do some service, they can ask any number of questions and then force them to do proper job because they have the power.
Right. Ms. Yuar, as a final question, I want to keep a general question, propose a general question to you so that you can give a more broader answer to this. As we look at the 22nd Amendment, now this came during a difficult time for the country, and it came as a basic need to implement. If not, the country will not come out of the sort of crisis situation it is in. When you zoom out and when you look at this, and someone who has been practicing for a very long period of time, what do you think are the salient features that are really positive in this, that we need to take forward? What do you think we need to really look into more? And where do you think this amendment would lead us to?
Yeah. Now, when we consider the cabinet also, it has been specifically mentioned 30 people only. Yeah. So you can't have it on your own way of appointing people. So even the ministers being appointed and their portfolios are being given to them, the president has to get the advice. That is clearly stated. Advice. Earlier, if he wishes only, he can ask anything from the Prime Minister. Here, it is clearly stated, President should take the advice of the Prime Minister and appoint people. And even if we are removing also, he has to get the advice of the Prime Minister. That shows that the President's power had been given to the Parliament. Parliament is being controlled by the Prime Minister, so he is the person who is there in the Parliament. So his advice will be very important at this stage. And then the other important thing is when the Prime Minister is being appointed, the same it is clearly stated when a person can control the parliament, he will be appointed as the prime minister. So after appointing him, the president has own way of doing things, earlier constitution amendment. But here, of course, it is clearly stated advice should be taken to consideration. And then the other important thing is the maximum, even if they are appointing other ministers also, it should not go beyond 40. So they can have amalgamated things, and then they can have other parties involved, as the president clearly stated that we should work together, and they ask parties to come forward. If they are willing to do so, they will be given only maximum 40 cabinet and non-cabinet ministries. So that is how you should proceed. At this stage, we can't spend a lot of money, and a lot of facilities should not be given to them. If they are ready to work hard, then they can come forward. And at this crucial juncture, if they are ready to do so, they should be given the power to do so.
Yeah.
And then I saw that the Prime Minister, the President is going to appoint various committees. So Parliament committees are very essential. Because of the Constitution, if we say that we can do everything, no, it is not possible. We have to have, inside the Parliament, there should be a lot of committees which they can go into details and then do the service. By doing that, it is a very limited period if we can work together, and if we are in a position to come out with this crisis with the help of IMF, and we can't get the help of IMF and say that all problems will be solved.
Yeah.
We have to do our job properly, and especially government servants should be they should be adhered to the present situation, and they should know that they are doing a service to the people. If they are not going to do their proper job, the parliamentarians they can't do the maximum because their purview is very limited. Yeah. So with that atmosphere, if we are in a position to work together, and within 1 year period, we can go to election and see what steps we should take for the betterment of our country.
Right. Very enriching discussion. Thank you so much, President's Counsel. You are Silva, for taking the time and explaining this very pertinent and important subject matter to our viewers. The former president of the Bar Association, and I'm sure almost all of our viewers would have seen him in the media these days because he's explaining a lot of important things. Once again, sir, thank you so much for joining us.
Thank you very much for inviting me again to this particular program. And I hope that people can understand, and they have all responsibility. If we are going to do our responsibilities in a proper way, then we can come out with this situation. We must think positive and proceed further.
Right. All right. The individuals in positions of power have a large role to play in application and delivery based on the provisions of the law. It is not merely how well written the legislature is. Former Prime Minister of Singapore, Lee Kuan Yew, once said, "A nation is great not by its size alone. It is the will, the cohesion, the stamina, the discipline of its people, and the quality of their leaders which ensure it an honorable place in history." That is all from us here at Law, Land and Liberty. If you had missed today's program, you can watch the entire episode on our YouTube channel, youtube.com/Ada English. Join us again next week as we break down a contemporary legal topic. I'm Derana. Have a great night.